Hi, Kyla. How are you?
I'm great, thank you. Thanks for having me.
Well, it's very nice to see you again. This is not your first time here on this show or on Wicked. And actually, congratulations, because you are now part of the Wicked executive team.
Thank
We're
you.
very happy to have you, Kyla, because you've been very heavily involved and invested in Wicked, and we really appreciate everything you've done. Um, you're known in BC for your work in impaired driving, but now I think you're being known throughout the country for your work in this niche area, and you're very known for your knowledge about impaired driving cases. And that's exactly why I have you here today again as my guest, because you're going to be giving us all the updates on impaired driving. So I'll let you be in control here and just tell us what's going on in the world of impaired driving.
There is so much that's going on right now. Since, the changes in December 2018, there's been a lot of litigation about the constitutionality of a number of those changes, interpretations of provisions of the criminal code, with, language and section changes and things like that, and new requirements for certificate evidence, all of which have been causing a lot of litigation. And it's actually an exciting time to be an impaired driving lawyer because a lot of cases are going to the Supreme Court of Canada. So we've
Mhm.
had four significant cases be heard by the Supreme Court of Canada that help people defend impaired driving cases to some extent and certainly clarify the law on a lot of issues where there was conflict and where there was confusion, particularly stemming from the way the criminal code used to be written.
Do you think, though, that there's going to be any more leniency? Because the law is pretty tough right now. It's very difficult to defend these cases. Do you have hope that there's going to be any kind of positive change in terms of defenses?
It's very interesting actually because I would have thought no if you had asked me,
Yeah.
in 2019 what the Supreme Court of Canada was going to do when it was faced with a lot of issues. But what we've actually seen has been by and large a pattern from the Supreme Court of Canada of respect for individual liberties as they relate to what happens to people in impaired driving investigations and a desire to seemingly to uphold those. So that's actually made the landscape a lot better for defending these cases. And I'm happy to explain a couple of the biggies
Yes,
that have come
please
up.
go ahead.
Sure. I guess we'll start with sentencing first,
Mhm.
because I like to take a little credit for this one, which is the case
Yeah.
of Wolf. That case involved the provision of the Criminal Code 320.24, which allows a judge to impose a discretionary driving prohibition. And it used to be under the criminal code that you could impose that discretionary driving prohibition for the murder offenses, the manslaughter offense, and for criminal negligence causing death or criminal negligence causing bodily harm. And when the legislation was amended, they removed the references to those sections and they just referred to the sections within the standalone regime related to driving offenses. And so this issue arose. The Saskatchewan Court of Appeal in Wolf said, nope, you can't impose a discretionary driving prohibition for a criminal negligence causing death. The Ontario Court of Appeal said, oh wait, yes, yes, you can. It's absurd that you can't because
Yeah.
criminal negligence causing death is worse than dangerous driving causing death. So, that it wouldn't make sense that you could get, arguably a lesser sentence. And then the reason I take credit is because I argued the same issue in the Court of Appeal in British Columbia. And our BC Court of Appeal followed the Saskatchewan Court of Appeal in Wolf and also did their own analysis as well to come to the conclusion about it, looking a little bit at provincial statutes and how they were amended following the decision, or sorry, following the amendment to the criminal code. And then that case was cited heavily in the Supreme
Nice.
Court of
Yeah.
Canada's judgment. So I was like, hey, the Crown had applied for leave and they didn't get it. But I was like, it's almost like I was there.
Yeah.
So yeah, the good news coming out of that is that if you are charged with criminal negligence causing death, bodily harm, or a murder or manslaughter offense involving a car, or even like assault with a weapon involving a car, you can't get a driving prohibition under the criminal code. Provincial statutes have been amended in response to this to allow provincial driving prohibitions and to, in fact, in BC at least mandatorily impose them. So, there's still ways to lose your license, but it does also help for people who, if you have a criminal record, you're not worried so much about the criminal record consequences, but the driving prohibition would destroy your life.
Yeah.
It may assist in determining whether you actually want to take something to trial or whether you want to plead and, keep your license.
Hmm.
So that
Okay.
one's super good. And then there's a lot that has happened in relation to like private property rights and the old like your home is your castle rhetoric is coming back. It's very interesting. The big case that sort of I guess kicked this off is a case called McCollman.
Hmm.
And that came out of Ontario. Mr. McCollman was driving down the road. The officer thought, "Oh, I'm going to stop him for a random sobriety check," which officers are allowed to do under every
Yeah.
provincial or territorial act.
Yeah.
They have a power to do that. But the power was limited in Ontario's legislation and in every other province and territory as well to only when a person is operating a vehicle on a roadway. And the officer didn't activate his lights or try and pull Mr. McCollman over until after he turned off the roadway. And the Supreme Court of Canada said, nope, that's a breach, Section 9 violation. You don't have the right to do that. But the downside of that case is that he was like super, super plastered. And they admitted all of the evidence under 24-2 because there was some confusion and uncertainty about the extent of the authority. And also the evidence was really reliable given his state of intoxication. So it's
Hmm.
a bad 24-2 case, but it's a good case for, respecting the constraining the right to stop. And, now that there's this clarity from the Supreme
Yeah.
Court of Canada, obviously the 24-2 analysis would go a different way. Um,
If you have better facts, like in a different
yeah,
case where you have better
a
facts,
more sober
you can
person.
rely
Yeah.
on the charter part, the breach from this case, and then rely on your facts to distinguish and see how, and say that and argue that it should be excluded under 24 too.
Yes, exactly. And then in addition to that, the Supreme Court heard, I guess at the beginning of March, a case called Singer, which is maybe my favorite case that's sort of updated things in the impaired driving context in the last couple of years, which is a case about the knock and approach doctrine, right? The police have the right to go up and knock on your door, approach your property and knock on your door. Um, and that's an implied invitation to all members of the public to do that. And the Saskatchewan Court of Appeal, God bless them, they're doing good work. They said, well, no, because the knock and approach doctrine needs to be constrained to what would a reasonable person actually permit somebody onto their property to do. And you're not going to, no reasonable person is going to be like, oh, yeah, I'm going to permit the police on my property to investigate me. So they essentially said it does not apply to approaching and investigating for impaired driving offenses or, arguably for any other offense. But this was an impaired driving. There was a tip about a guy who might be driving drunk, and they showed up. They found him passed out in his car in the driveway, knocked on the window, woke him up. So they didn't even knock on the door of his house. He
Yeah.
was inside. Um, and that was still enough to have the entire thing found to be unconstitutional. So the Supreme Court of Canada's heard that. The arguments, if you get a chance, watch the hearing because the arguments were very interesting and the court was very split, it seemed, in the way it was questioning
Yeah.
people. But there did seem to be sort of an undercurrent in the most of the judges' questions about this notion that, yeah, you do have some level of privacy and you can't just have carte blanche for police to come up on unsubstantiated tips and
Yeah.
start to investigate you when you're in your property. So
Yeah.
that's going to be a big one. I'm excited about that.
And hopefully it will go the way we would like it to go. I
Yes,
mean, that's
yes.
the thing. Like, I mean, if it ends up being something that is not going to be very good for individual rights, then that could be a very bad case.
It could be. And some of the questioning was sort of like, well, couldn't you just not answer the door? And I don't love that questioning. I don't love
Yeah.
that line of thinking because yeah, if you own a house and you can see who's outside the door from like whatever windows you have, yeah, you could just not answer the door. But if you live in somewhere where you don't have that opportunity, to, you don't either can't see who's behind the door or you're in an apartment building, right? And you don't have, so much control. You shouldn't have fewer rights because of that. And I think if you're making it a situation where you have to somehow magically know that the police are there to investigate you before you make the decision about
Yeah.
whether to open the door, that's it's unfair.
Yeah. Yeah. Well, hopefully we'll have a good decision and we'll see then. And this one is on reserve, right? Like the we're still waiting to get that decision. Okay. So what else is happening?
There was a great Supreme Court of Canada decision that resolved the conflict between sort of Ontario, Alberta lines of authority and BC, Saskatchewan lines of authority on immediacy in relation to
Mhm.
roadside breathalyzer testing. And that case dealt with a delay waiting for an officer to bring a roadside breathalyzer. And in Ontario, and Alberta, the courts had sort of given this immediacy requirement a flexible interpretation that
Yeah.
meant that it could give way to investigative activities. And BC and Saskatchewan took it to mean no, it immediately means immediately. And unless there's something related to the, operation of the device that you need a delay for residual mouth alcohol contamination or something like that, or unusual circumstances, right? The person runs off from the
Yeah.
scene or starts to get combative. Um, there is no justification for any other delay. And the officer needs to be, at the time that they make the demand, in a position to administer that test. And if they don't, it's not lawful.
Mhm.
So that's a great one. The Supreme Court of Canada made it very clear. Immediately means immediately,
Yeah.
immediately. So they adopted the BC and Saskatchewan
Saskatchewan
line of
line.
authority.
Yeah.
Yeah, which is good. And it's really helpful because there was so much confusion and you'd end up litigating the immediacy requirement in every single case because Crown would come with cases from one province, defense would come with cases from another
But I
province.
mean, how silly is it though that we have to argue what immediately means? I mean, I just find it really ridiculous.
It's completely ridiculous. But I think that's also partly like the nature of impaired driving cases, is that arguments tend to end up being made about silly little
Yeah.
ridiculous things. And there's a couple of reasons I think for that. One is the more tough the government makes the law, the more
Yeah.
defenses they legislate away, the more creative we have to get in response to it to defend our clients. And so we are going to be arguing about minutia, and the judges are going to have to focus on minutia because that's the difference between somebody being found guilty and somebody being acquitted. And they have to take that seriously.
Well, I mean, what I find is frustrating is that it also, even if we agree on what immediately means, it seems like sometimes, especially also in some jurisdictions, Ontario being one of the tougher ones, that it always allows officers to get away with some silly explanation that, oh, but it's okay. And officer safety, obviously, is always uh, I still don't know what they really mean by officer safety because it means a whole kind of things. And that's what I find frustrating is that it seems to always allow officers to do other things and to expand what immediately it means. So, like,
There
you
was
know
a
more about that. So
Yeah, there actually was a good case about that sort of like officer safety
yeah.
concept that came again out of the Saskatchewan Court of Appeal.
Mhm.
It's called McCorriston, and it was another 5-minute delay doing an ASD test. The officer runs Mr. McCorriston's plates, has some reason to pull him over related to what he sees on the screen, pulls him over, walks up to him, identifies him and then goes back to his police vehicle. And when he comes back to Mr. McCorriston, he's on the phone and he hangs up his call and the officer reads the ASD demand. And Mr. McCorriston says, I don't think so. I think too much time has passed. And the officer tried to justify these like 5 minutes of delay, such a tiny amount of
Yeah.
time, by saying, well, it was officer safety. I had to verify that this person I was dealing with didn't have any warrants or a history of violence or gang activity. It was my safety that was going to justify
But
this.
but that's the thing, like what in that context made him worried about all these things?
And that's what the Saskatchewan Court of Appeal said is like there was nothing about his behavior. And having run his plates before stopping him, he already knew who the likely person he was dealing with
Hmm.
was and would have had information about that. And so that's not a justification under safety. You can't create some officer safety justification out of a nebulous concern. There has to be something about the interaction that gives rise to that.
Yeah. exactly.
So
And the circumstances of the interaction, the context, and everything. So, okay. Um, Kyla, I know when we were chatting about just before we started recording, you did mention an interesting case where there was some kind of technicality, which is also another ridiculous kind of situation. But I think it's a fun case to mention as well.
yes, I will give props to Mark Brayford in Saskatchewan for this one because this was I think his genius. So in impaired driving cases, obviously there's a certificate
Hmm.
that is filed to put in the readings, and in Alberta, their certificate referred to an attached document. The Crown filed that document along with the attachment, but they weren't stapled together. And so the defense objected and said it's not admissible, it doesn't comply with the requirements, it doesn't attach the other document. And the person was acquitted, literally over the absence of a staple. Unfortunately,
Yeah.
arguments like that about silly things may persuade trial level judges who are, maybe looking for ways to acquit. But appellate level courts don't like those things. And so that was very quickly overturned.
Yeah.
But still a really interesting discussion about, compliance with the requirements of the criminal code. And there's a great practice tip that also comes out of that case, which is about objecting to the certificate at the time that the Crown is attempting to file it. It's very important that you make that objection at the point that they attempt to tender it and don't save it until the end and lay some foundation. You don't have to reveal your whole hand, but you do have to lay at least some foundation at the point that you're bringing the objection. So
Okay.
it's at least a helpful decision, even though it's all about a staple.
Yeah. Yeah. Well, another helpful thing to know is that it seems like Saskatchewan has some really good cases when it comes to impaired driving. So maybe we should read more of their cases on the defense side and try to use their arguments and make the law a bit more lenient in Ontario because it is not when it comes to impaired driving. Are there any changes when it comes to the actual machines, like the intoxilizer and the device, the approved screening device?
There haven't been any in BC, other than they got a new batch of serial numbers, but I don't think that
Hmm. Yeah.
not particularly interesting. I'm not sure about other provinces, but I do know, I have heard through the grapevine that there is the RCMP right now is in talks to replace the Intox ECIR2, and they're looking at some other model. So we may be seeing them go like nationally to like a Data Master DMT, or something else, not sure which, but they're exploring replacing it and having something that's consistent across the country. So that'll be very interesting.
Okay. Yeah, I mean, that will open up a whole line of new cases if that
Yeah.
happens.
Yes. And
And
oh, there's one
yeah,
more thing. It's very important that I
yeah.
forgot. It just came back to me right now. It's reasonable excuse in refusal cases.
Hmm. Yeah.
That so it used to be there's a case Supreme Court of Canada decision called Gillespie that said that if you were trying to argue you had a reasonable excuse for not complying with a demand, that you had to prove your reasonable excuse on a balance of probabilities. And this was because of a provision of the criminal code that said essentially that. And that was repealed. It's outside the impaired driving regime, but it was repealed around the same time as the impaired driving legislation was amended under a different bill, Bill C-51. And so two cases have come out, one from Ontario and one from Alberta. And I just had it adopted in BC in one of my cases, that says that now you only have to raise your reasonable excuse, give it an air of reality, and then the burden shifts to the Crown to disprove it. So that's huge. It's so
Yeah.
helpful on refusals.
All right. And so we did talk about sentencing. We talked also a bit about some of the like um some of the cases, the upcoming cases. And in terms of, I mean, you also talked a little bit about some charter issues, but is there more to know in terms of charter?
Uh,
Because I think it's still the best way to win these cases, right? It's still to
it
make a
is.
charter argument and hoping that, we get that 24-2 and exclude the evidence.
Yeah, it's definitely the best way to win an impaired is through charter issues
Yeah.
because the technical issues almost never pan out. Um, The I think
Unless they
what
change their device, right? And
yes,
then we start having problems with them.
maybe, hopefully.
Yeah.
Um, the I think the biggest thing is to pay attention to other cases about warrantless searches that come out of the Supreme Court of Canada. I've had a lot of success applying the principles from the Zacharias case, which
Hmm.
is actually a case about like some warrantless search information that went into an ITO. And when that search was found to be unlawful, it was removed from the ITO entirely. And the discussion in Zacharias is about how you cannot authorize a later search based on a warrantless search that's conducted unlawfully.
Yeah.
And it's been really helpful because of the progression of searches that happen in impaired cases, where vast majority of cases people are pulled over, there's an ASD, then there's a breath demand. It essentially allows you to get over that hurdle of the ASD is unlawful, but I still have to argue 24-2 because Zacharias basically says, nope, you kind of, to some extent, skip over 24-2 here. That automatically invalidates the breath demand, which means now you've got a cascading series of breaches,
Yeah.
and everything should be inadmissible as a result. So that's been helpful. So I like to try and like, take those little charter nuggets from other cases and throw them into the
Yeah.
impact text.
Yeah, I mean, we have to, right? Because I mean, the defenses are a bit challenging right now. So we kind of have to expand the charter analysis. But it also seems to me, from what you're saying today, that the courts in BC and Saskatchewan are also more receptive to new arguments than they are in Ontario, for example.
It does seem that way. I don't know if it's that in Saskatchewan they see a lot more impaireds because they didn't have a roadside prohibition regime until very recently, or in BC they don't see as many impaireds, and so it's more interesting to judges. And we don't get a lot of charter litigation here anymore because we also kind of love drugs and we don't prosecute drug files very often. So judges don't really get to engage with the charter as much, and I think that makes it more fun and exciting for them.
And just remind me, Kyla, in BC, I think you can still ask for a discharge in these, because I know in some provinces, and BC was not one of them.
You can't ask for a discharge in any province anymore. They
Okay.
actually removed that from
Okay. Yeah.
yeah. So, I mean, arguably there is an ability potentially to constitutionally challenge that
Yeah.
because I think, especially if you think about the collateral consequences of a conviction triggering immigration
Right.
consequences, automatic deportation, not being able to get a discharge is disproportionate to the gravity of the offense. You'd need a really good case, like somebody's sleeping in their car in a parking lot and the officer comes up and knocks on the window and, they blew 90 or something, right? You need a good set of facts for that. But yeah, I think that it is possible. I've filed those challenges in a couple cases, but unfortunately, I have not been able to argue them because I won one of the trials, so I didn't get to sentencing.
Yeah.
And the other one, I got a deal to a lesser included that allowed me to ask for a discharge. So
Yeah. I mean, like that would be really great if we ever get to a point in these cases where a person doesn't get a conviction because many of the people who end up being in impaired driving situations are really far removed from crimes. I mean, there are some other areas where people like drug trafficking, chances are people are, this is their job. So, I mean, but impaired driving is really very sad to on all levels. And just to have a conviction from sometimes one mistake is really very difficult for our clients. So,
it is. Yeah, I think it's disproportionate. I've ranted and raved at the wall basically
yeah,
about this, but I don't think there's any political appetite to make things more lenient for impaired drivers,
yeah,
especially in the climate right now where we have, Pierre Poilievre talking about implementing a three strikes rule.
yeah. No, I mean, definitely right now is a crazy time and the legislation seems to be getting a bit tougher, but hopefully one day we'll see. So, so tell me, Kyla, anything else that you want us to know, some updates?
The last thing I'll say is that there's one case out of BC that has been heard on an issue that hasn't had any reported decisions anywhere else. The case is called Ward, and it's about applications to cross-examine the qualified technician,
Hmm.
which, you have to bring an application, you have to serve it 30 days in advance of the trial on 30 days notice to the Crown. And because there was no reported case law on it, the judge in that case had to determine what is the actual standard that you have to meet in bringing this application. And he determined that all you have to do is raise an air of reality to there being an issue that should warrant cross-examination. And it can also be done on the basis of statements by counsel. You don't have to file an affidavit from your client or essentially put them in the position of potentially revealing their defense or opening themselves up to cross-examination. So that's a good decision.
Okay, very nice. So that was really very good to hear all these updates, Kyla. And I really hope a lot of people will be listening and tuning in to this episode because, I mean, you're honestly one of the best on on these issues of impaired driving cases. And it's always good to hear directly from you and all the updates. And Kyla, you're always going to be a guest here on this show. It's always nice to see you. And hopefully, we'll see you soon in person as
Yes,
we
I hope
were
so.
chatting. Thank you so much, Kyla. And just for everyone to know, Kyla is very active and very present on social media. I think you're on all the major platforms, whether it's X, TikTok, Instagram, and many others. I'm not on everything, but I know that you're very present everywhere. So I encourage everyone, especially lawyers who do a lot of impaired driving, if you're not already following Kyla, follow her because you will really learn a lot from her. And I also must say that I know on Instagram you post a lot of videos where you talk about, especially the machines, the approved screening device. I think I've seen a few videos on that, and they're funny, but they're also like you can really learn a lot. So I really encourage you to all follow Kyla if you don't already follow her. And thank you so much for your time, Kyla.
Thank you.